Hello everyone, welcome to another episode of Mind Map. Today's topic of discussion is public interest litigation. First of all, we will discuss about the introduction of the topic. Then we will discuss about some landmark judgments, significance of PIL, weaknesses, and lastly way forwards. First of all, moving on to the introduction of public interest litigation, that is PIL. PIL is the use of the law to advance human rights and equality or raise issues of broad public concern. The concept of PIL has been borrowed from the American jurisprudence. In Indian law, PIL means litigation for the protection of public interest. It is litigation introduced in a court of law, not by the aggrieved party, but by the court itself or by any other private party. It is the power given to the public by courts through judicial activism. It can be filed only in the Supreme Court or the High Court. It is different from writ petition, which is filed by individuals or institutions for their own benefit, whereas PIL is filed for the benefit of the general public. The concept of PIL is suited to the principles enshrined in Article 39A of the Constitution of India to protect and deliver prompt social justice with the help of law. Now let's have a look at some landmark judgments. The seeds of the concept of public interest litigation were initially sown in India by Justice Krishna Iyer in 1976 in Mumbai, Kamagar Sabha versus Abdul Thai. The first reported case of PIL was Husainara Khatun versus State of Bihar in 1979 that focused on the inhuman conditions of prisons and under trial prisoners that led to the release of more than 40,000 under trial prisoners. A new era of the PIL movement was heralded by Justice P.N. Bhagwati in case of S.P. Gupta versus Union of India. By this judgment, PIL became a potent weapon for the enforcement of public duties where executive action or misdeed resulted in public injury. Justice Bhagwati did a lot to ensure that the concept of PILs was clearly enunciated. The Supreme Court in Indian Banks Association, Bombay and others versus MS Devkala Consultancy Service and others held courts may investigate personal grievances in public interest for justice even in private litigations. MC Mehta versus Union of India. In a public interest litigation brought against Ganga water pollution so as to prevent any further pollution of Ganga water. Vishakha versus State of Rajasthan. The judgment of the case recognized sexual harassment as a violation of the fundamental constitutional rights of Article 14, Article 15 and Article 21. The guidelines also directed for the Sexual Harassment of Women at Workplace, Prevention, Prohibition and Redressal Act 2013. Significance of PIL. PIL is an important instrument of social change and for maintaining the rule of law and accelerating the balance between law and justice. The original purpose of PILs have been to make justice accessible to the poor and the marginalized. It democratizes the access of justice to all. It helps in judicial monitoring of state institutions like prisons, asylums, protective homes, etc. It is an important tool for implementing the concept of judicial review. Now let's discuss about weaknesses of PIL. PIL actions may sometimes give rise to the problem of competing rights. For instance, when a court orders the closure of a polluting industry, the interest of the workmen and their families who are deprived of their livelihood may not be taken into account by the court. It could lead to overburdening of courts with frivolous PILs by parties with vested interest. PILs today has been appropriated for corporate, political and personal gains. Today, the PIL is no more limited to problems of the poor and the oppressed. Cases of judicial overreach by the judiciary in the process of solving socio-economic or environmental problems can take place through the PILs. PIL matters concerning the exploited and disadvantaged groups are pending for many years, and inordinate delays in the disposal of PIL cases may render many leading judgments merely of academic value. Now lastly, moving on to the way forwards. Former Attorney General Soli Sorabji opinions 3 basic rules for regulating abuse of PIL. Reject dubious PIL at the threshold and in appropriate cases with exemplary cost. In cases where important project or socio-economic regulations are challenged after gross delay, such petitions should be thrown out the very threshold on the ground of laches. Just because a petition is termed as PIL does not mean that ordinary principles applicable to litigation will not apply. PIL petitioners should be in strict terms such as providing indemnity or giving an adequate undertaking to the court to make good the damage if PIL is ultimately dismissed. Now it's time for the practice questions. First of all, prelims based question. With reference to public interest litigation, consider the following statements. 1. Grievance written on a postcard can also be admitted as a PIL. 2. Locus standi is not needed to file a PIL. Which of the statements given above is or are correct? 1 only, 2 only, both 1 and 2, or neither 1 nor 2? Send the answer of this question in the comment section. And now mains practice question. Every matter of public interest cannot be a matter of public interest litigation. Comment. So that's all for today. Stay tuned for the next episode. Thanks for watching. For more informative content, like, share and subscribe. And do not forget to press the bell icon to get the notifications.